We're live.
Good morning. This is Monday, the 8th of March, and this is a voting session of the House Judiciary Committee. There are a number of pieces of legislation we have to address, along with an amendment to House Bill 670, which we will wait to deal with until the end of the voting session today, to give people some time to digest what is a relatively small amendment to that piece of legislation. There are bills that have gone through subcommittee, and I'm going to start with them. So House Bill 128 is where we will start. House Bill 128 is Delegate Stewart's bill. I believe that this went through Delegate Moon. Is he on the line? There he is. Delegate Moon's committee, subcommittee. Delegate Moon, you want to talk about what the subcommittee did?
Sure. House Bill 128 adds age and gender identity to the hate crimes law, and it attempts to create an anti-bias education program that could be a part of a defendant's sentence. The Senate has already passed the bill, and they had amended this to create consistency in terminology with how gender identity is referred to. So we adopted those amendments to make the House bill the same as the Senate bill. So with that, I would move the amendments.
Motion on the amendments. Is there a second?
Mr. Chair?
Delegate Cox. Well, I heard a second first, so we'll go to discussion now. Delegate Cox?
Thank you. I might have missed it, but were these amendments sent in the email, or where do I see the amendment? I'm not finding it.
You should have received a packet from Dylan that had a PDF of compiled amendments for today's session.
That went out in the packet from Dylan.
Okay, I think I just found it. Thank you.
Okay. Well, and while you're looking, and he's putting it up on the screen, whoa, and then taking it down off the screen. One second, let's give him a chance. There we go.
Can we be reminded of the subcommittee vote?
Delegate Moon?
This one was only one opposed.
Who is that?
Grammar, I believe.
Delegate Cardin first, then Delegate McComas.
Thank you. First of all, I think I'm on the criminal subcommittee, but I don't remember. I must have missed this subcommittee meeting. I just wanted to just remind the body, because I'm going to mention this in the next bill that we discuss, that this includes gender identity in the hate crime statute, which is vitally important, but also important for the next bill we're going to discuss.
You were definitely at that meeting now. I remember that.
Delegate McComas.
Thank you, Mr. Chair. Just a brief question. What was the vote in the Senate in JPR and then at the whole Senate? Since I understand this has been passed out of the Senate and we're trying to conform the two.
Let me see what the Senate vote was.
Senate
was
220.
45-0.
Okay, and what was it in JPR? It's Senator Hedelman's bill, if that helps.
In JPR, it was 10-1.
Who was the one? I'm just curious.
Castley.
Castley.
Okay.
All right. Are there any other questions regarding the amendment or any comments regarding the amendment?
Mr. Chair.
Delegate McComas.
I just have one question. I know we're having the University of Maryland to do a study, but I see where you've added age. And I'm all for that. My concern is that was the university system have the ability to deal with any discrimination or hate crime regarding age? Because that seems to be probably an AARP expertise or so I'm just wondering if AARP ought to be included as far as to help develop the curriculum, because that's their specialty.
Delegate Moon?
I don't think there's anything that would preclude the university from doing that. I guess the question would be whether it needs to be specified in the law. I would suggest at this point in the game not to make the versions between the House and Senate different on something like that.
Age is out of the bill anyway.
Claire, say that again, please.
Age discrimination is out of the bill. The Senate amended age out as a basis for.
Okay. Well, there you go.
I was going to say, I thought I saw that age was out of the bill, not in the bill, but Delegate McComas again?
Well, so does that mean that we can just keep knocking old folks down? That it's very obvious they're old? I mean, I think it should be in the bill, and I'm bailing on it, to be honest with you. I think that's not good.
All right, are there other comments about the amendment?
I think the amendment's fine. Age is still a protected class, so.
Delegate Arakan?
So yeah, that was my question. Is age still a protected class, or why was it in the bill originally if it's already a protected class?
It's not a
That's who
protected
the
class
sponsor
under the
tried-
hate crimes.
Yeah, that's who the sponsor was trying to initially include in hate crimes legislation.
So it's a protected class, but it was not covered in the hate crime statute prior.
It's a protected class for like employment reasons and other
Housing
reasons.
discrimination.
Housing, right.
So, I mean, I would ideally like to see that it be included, but I also have heartburn whenever we change a bill and make it not conform to the Senate version, because there's a very good chance it will die. And then what I wanted to have included wouldn't have mattered to begin with. So I don't know, I guess I'll wait and hear what other people have to say about potentially changing it to not conform.
I mean, I also generally feel like, Mr. Chair, if you don't mind, that
Delegate Moon?
that we need not hold up progress for one group because we didn't catch everyone, especially when the bills are already moving. And so, we could do it here, but the Senate already took an affirmative action not to have that conversation at the moment. So I think you're onto something.
I don't remember from the hearing with respect to older people. I don't remember hearing a great deal of, or in fact, any examples of hate crimes being carried out necessarily against people because of their age. I do know of a lot of a significant problem with hate crimes related to a person's gender identity. Delegate Cox.
Thank you, Mr. Chair. So I am trying to remember the hearing on this. And does this, and maybe Delegate Moon can help me, does this change? I thought the statute in the criminal law already included gender identity. Does this just put it back to gender identity and strikes the gender related identity or expression language, this amendment?
Yeah, I mean, as to the Senate, I don't think that aspect of it was substantive, no.
So what does the bill actually do now that it's been amended in the Senate?
It puts the term gender identity into the hate crimes law and then authorizes a judge to issue a anti-bias education bit as part of a sentence. And so in tandem with that, it would have a program be created that can fulfill that purpose.
So
So right now, I'm sorry, Mr. Chair.
no, go ahead, Delegate Cox.
I was just curious. So right now, there's no gender identity protection in the harassment language of the hate crime statute?
Under the
There is.
law, yes.
It's the terminology is not ideal. It's not as up to date as it could be. Currently, gender-related identity is included within the definition of sexual orientation under the current law. And so what the bill does is it takes that out, takes gender-related identity out of the definition of sexual orientation and adds a definition of gender identity, which is defined in the state government article. So it's just really updating terminology in that respect.
And in terms of harassment under the criminal statute, that has a pretty high test, I think, correct?
This is a hate crime. This is not harassment. This is somebody who, because of that person's particular race, color, religious belief, sexual orientation, gender, or under this bill, gender-related identity or expression, disability or national origin, or because a person or group is homeless, it covers whether it raises a penalty based on that, as opposed to harassment, which is separate. It's a different crime than a hate crime.
But Mr. Chair, but again,
than harassment.
As to this aspect, I don't really think it's a substantive change.
No,
Um,
it's a change in terminology more than
yeah,
a change in substance.
like sexual orientation was already bracketed in the law to have this in it, and so it's a little bit of reorganization and housekeeping and terminology cleanup.
So I don't want to belabor this, Mr. Chair, but I just, to follow up on that, this will now apply though to, I was reading the fiscal note and it says this definition will now apply directly to 10-304 harassment, which I guess my question in that regard is, does this relatively minor change from the sexual orientation to changing to its own definition of gender identity, could that potentially create a new crime for individuals who I guess what I'm asking is there a protection for expression, freedom of expression of maybe, I'm thinking of girls sports and maybe there's a group, I don't know. I'm just wondering, is there a protection for freedom of expression in the context of the debate that's going on now with these high school and college sports? That would be my question. Is that still protected?
This addresses the hate crime statute, so I don't know what that would have to do with whatever issue that is being raised there. Under the hate crime statute, this applies only when someone commits a crime or threatens to commit a crime against that person or group, defaces, damages, or destroys, or attempts to threaten to deface, damage, or destroy the real or personal property of that person or group, burn or attempt to threaten to burn an object on the real or personal property of that person or group, or commit a violation of item number 1 that is that results in unless it well, I'm sorry, I'm reading that wrong. I'm reading section 2 of 10-304. It involves a separate crime that is a felony or results in the death of a victim. So I don't think this has to do with issues like you were raising.
So the fiscal bill the fiscal note that says harassment.
Delegate Cox, to the
Yes.
extent that a violation of 10-304 in the hate crime statute could be based on commission of the crime of harassment under 3803 of the criminal law article, The definition of harassment is a person may not follow another in or about a public place or maliciously engage in a course of conduct that alarms or seriously annoys the other with the intent to harass, alarm, or annoy the other after receiving a reasonable warning or request to stop by or on behalf of the other and without a legal purpose. So I think that rises far above mere First Amendment expression.
That's my question. Thank you. Thank
Okay,
you, Claire.
Delegate Crutchfield, then Delegates McComas and Arakan. Delegate Crutchfield?
Thank you, Mr. Chair. I just wanted to mention that normally I am definitely a proponent for all of the protected classes to be included in any kind of hate crimes bill. But in particular, when we talk about age under the protected class, we're really talking about people that are just over 40, period. Okay, so we're not talking about any particular 70, 80-year-olds, et cetera. We're talking about everybody over 40. So I just want to bring that back into the discussion that age will be a huge parameter for us to deal with in a hate crimes bill of this nature.
Delegate McComas?
Thank you, Mr. Chair. Just briefly, I would say that, okay, if you want to limit age, because all I am seeing are on television is all these people attacking older people, whether they be white or black or Hispanic. And, you've seen them, throw them down on the ground. And when older people, bones are easily broken, they have medical conditions, they're fragile. And I know that there's an uptick in the, what do I want to say, sort of like hitting people that are Asian, and doing things to Asian people that are older. And I just think that we need to protect our senior citizens. So, I mean, if you want to put an age on it, that's fine. But it should, and certainly disabled people too. They ought to be a protected class as far as a hate crime. Someone in a wheelchair, somebody on crutches, someone with a cane, someone with an oxygen. I mean, I think, okay, it's going to take care of these folks, but there's a lot more of the other folks that need protection. So let's, and I think that it would make the bill a lot more agreeable to the conservatives because these people are being targeted. And I think it's only fair that we protect them, and we have an opportunity to do it here. So I press the amendment, the age, and if Delegate Crutchfield has a parameter, that's fine. But I think we need to do that, and for age, and I will throw in disabled.
Delegate McComas, disability is already included in the hate crime statute. National origin is already included in the hate crime statute. Delegate Arakan.
So, yeah, sorry, I just want to follow up to make sure I understand what Delegate Cox said. So there, by changing the term of this, no schools can get in trouble for having a gender-specific sports team, can they?
This has to do with the hate crimes statute.
Right.
It doesn't have to do with sports teams in any way, shape, or form. It has
So
to
denying participation could not be considered a hate crime.
No, because it's not a crime to the best of my knowledge, it is not a crime to deny participation for someone who wants to play on the fill in the blank team.
Okay.
This is someone was assaulted and they were assaulted because of their gender identity.
Gotcha.
Assaulted and they were assaulted, and again, based on an animus, based on their gender identity, based on their sexual orientation, based on their gender, based on religious beliefs.
But we did fix that, right? It doesn't have to be only that anymore. It can be that and something else. We fixed that last year. That did pass, I hope. Because before,
it could be more than one of those categories, but it's an or so it could be any and all of those categories.
okay, so it doesn't have to be just a hate crime anymore, right? We did fix that. Remember last year we had that bill that they couldn't charge this person with a hate crime because they murdered the young Black student.
It changed the standard by which you're talking about Lieutenant Collins' law,
right?
And they didn't have to prove it allowed the state's attorney a little more latitude in showing not just that the person was, they had to show, were able to show more than, and look back and kind of developing the whole picture. It wasn't just specifically, this crime specifically occurred because.
Okay,
Which is in the first line of 10304, motivated either in whole or in substantial part by.
right.
Right.
Yeah, okay, great, thanks.
Right. Delegate Bartlett, then Watson, then Williams, then Moon. Delegate Bartlett.
Thank you, Mr. Chair. And this is a question regarding the statutes that we already have in place and the bills that are pending with respect to vulnerable adults. I was just wondering if Delegate McComas's concerns are perhaps addressed in some of the existing statutes or perhaps some of the bills that we're going to hear regarding vulnerable adults, because I do know that seniors are included in that group. So it's a question and also a presumption.
I think that if someone is motivated, and what the law says, they are motivated either in whole or in substantial part by another person's, and the classes are limited. So they're motivated by that person's disability to commit a crime against them. That's what the hate crime statute does. Delegate Ron Watson.
Yeah, just to clarify. So, I mean, I was struggling with a hate crime versus a crime against somebody who's vulnerable, right? And I'm challenging the age piece in here. I mean, if somebody commits a crime, you know, to a senior citizen, is that a hate crime, or is that someone taking advantage of somebody who potentially can't defend themselves? Is it appropriate to have age in here as a criteria? That may have nothing to do with hate. I don't think anybody hates senior citizens, but if they see a senior citizen that looks vulnerable, just like if they see a woman who looks vulnerable, that could cause someone to take action against them. So I just wanted some clarification on that. I understand everything, you know, McComas said, but many of those things, in my opinion, have to do with a vulnerable member of our community versus something specific to gender, sex, or true hate crime.
Again, age was taken out. I think that age is out of the bill. In the subcommittee amendments, age is no longer in the bill. So it's not included. So with that, for starters, I mean, I think you raise actually a good point. I do think, again, the issue here is that they're motivated in whole or substantial part by this characteristic. So you as the state's attorney, I'm going to need to demonstrate they are, you know, it is something built on animus. They hate old people. And it's not just they're taking advantage of someone because they are an older person. They actually hate old people. It is basically, it is arising out of that animus in whole or substantial part. And that's the point of the hate crime statute that we've had on the books. So I hope that addresses some of your.
Yeah, thanks.
Delegate Williams.
I was just going to say, can we call the question?
There's a motion on the previous question. I see Delegate Moon has someone who pipped him to the post. All in favor of moving the previous question, say aye.
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 Any opposed? Hearing none, we're moving the previous question. There's a motion and a second on the amendment that was approved by the subcommittee on House Bill 128. We will go ahead and raise hands. If you support the amendment as adopted by the subcommittee, please raise your hands. If you do, please raise your hand.
If we support the amendment?
Supporting the amendment
Okay.
from the subcommittee. Delegates Cardin, Shetty, Moon, Lopez, Bartlett, Arakan, Griffith, Williams, the vice chair, Sham, Conaway, Crutchfield, Watson, Fisher, Lone, and Davis. All those opposed, and I see Delegate Jones. All those opposed. Delegate McComas, Grammer, Cox. I see those three. All right, the amendments are adopted. We're now on the bill as amended.
Move the
Move
bill.
favorable as amended.
Second,
Motion and a second on the bill as amended. Is there further discussion? Seeing none, the vice chair.
yes.
Delegate Anderson is excused. Delegate Arakan,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
No.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
Thomas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes, sir.
Williams.
Yes.
Right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 17 to 3. Okay. Let's go now. Delegate Shetty, are you there? All right, we're going to recognize a couple people who may be watching us today. After the committee heard the bills related to sexting, the committee's office received a phone call or two from the Pages who were watching that hearing, and they indicated that they had some ideas and thoughts about that. And normally they would have the opportunity to visit with the delegates and talk with them, but of course they're not here. I asked Delegate Shetty to bring together the advocates on the different bills related to juveniles who engage in sexting. She did, and she engaged with Helena Sudina and Desmond Jordan, who both engaged with the advocates and the Delegate Shetty as part of that discussion. So I wanted to give them a shout out here in the voting session because we certainly do appreciate having their involvement. And we do appreciate that they reach out to the committee and certainly work with Delegate Shetty. And with that, Delegate Shetty, you have been in contact with the advocates. I think that Delegate Wilson is as good with the solution that you came up with, but can you talk to the committee about, I'm not sure actually whether we have the amendments in the packet though.
Do we have the interlineated bill by chance? Bill text?
Dylan, do we have the interlineated bill by any chance? Looking maybe long, oh, there we go. There's an interlineated bill. Okay, we're gonna have to make that a little bigger. Because a little more.
A lot bigger for those of us who don't have good eyesight.
Yeah, well, that's most of us at this point. So Delegate Shetty, why don't you begin and if you can talk to us about what you have done and where things ended up with the group.
Sure thing. Thank you, Mr. Chair. Hi, colleagues. Good morning. As the chairman mentioned, I met with the Pages, who had a lot of thoughts on our work in this space, as they will be impacted by any legislation that we pass, and they're also actually impacted by the lack of legislation in this space right now, as they are like in that age group that that this bill seeks to capture. I also worked with Lisa Jordan from MCASA, Gavin Potashnik on behalf of MSAA, Melanie Shapiro at our new organization, as well as Michal from OPD, who was the attorney that represented SK. We did a couple of things. We met a couple of times virtually, and then we exchanged a number of emails trying to really perfect and tweak this bill. All of the advocates had specific things that they really wanted to see, and I think we were able to incorporate something from everybody, including OPD. Ultimately, the bill before you today has the support of everybody, with the exception of OPD, who sort of philosophically has a difference of opinion on the approach that we're taking. So what this bill does is, as the original bill had created, it creates a mitigating factor for sexting as defined by a new definition included in this bill. Dylan, if you wouldn't mind scrolling to the definition section, I think it's on page 2, if you don't mind, please. Just go
Up.
Yeah, a little more perfect. Oh, right. Move a little more down, please. Great. Thank you. So what we did is we did a couple of things. In creating this refined definition of sexting, we mirrored some of the language in the child porn statutes to have some consistency in our criminal code in this space, but at the same time to exclude certain types of activity, right? So what we're trying to do is say that sexting is consensual, that it occurs between individuals that are within 4 years of each other. So that 4-year age band was really important, both to the pages as well as to the advocates, as it really captures, you know, the age within which most of this activity occurs. We also did a survey of all 26 states that have adopted different sexting legislation, and those that have created the strongest bills per the advocate recommendation included this 4-year age band. Anything outside of that creates a power dynamic that really does have a totally different, needs to be treated differently, right? Within 4 years of each other, it's more likely to be consensual. There's less likely to be a situation where somebody was coerced, or that there's a power dynamic that exists that would make this kind of imbalanced. We also included language that ensured that the picture included the person who was sending it, or themselves and the recipient. So that would capture like the scenario of SK in that first paragraph there in A1.1. We also, per the recommendation of all of the advocates, we removed the affirmative defense requirement, which would have put the onus on the child to show that this was, that they were or were not coerced. And that was a recommendation of every one of the advocates. They did not feel that we wanted to put that burden on the kid. And what this bill also does is it ensures that absent like really crazy circumstances, the child will not go to detention, but is most likely to just receive education as to why they shouldn't be engaging in this. And it was the recommendation, all of the advocates and the pages, that we consider for next year a broader bill that would require sex ed in middle school to include some component of sexting, so that the kids are getting educated more broadly about the harms that could come of it. I think that covers everything, and I'm happy to answer any questions.
Move the amendments.
We're going to, there's a motion to move the amendments.
Second.
And there's a second. All in favor of moving the amendments?
Do we have a discussion first?
You got to move the
Let's do
amendment.
that. Well, yeah, that's right. Let's go there. Delegate Arakan, then the vice chair, then Delegate Cox. Delegate Arakan.
Okay, I just want to make sure that this piece on our screen now is doing exactly what we intend for it to do. So we certainly don't want it to be considered sexting if the sender is more than 4 years older than the recipient. Okay, or the recipient is more than 4 years older than the sender. I'm confused why in the same section of what is not sexting, we've included 3 and 4 though. So if the child, for example, if the child was coerced, then it does not fall under sexting. So then the child could be prosecuted for child porn.
No, if it's not, if it does not include conduct. So we're carving out sexting, the definition of sexting, and treating sexting as a lesser issue than child pornography. So
right.
So sexting does not include when the child was coerced, because then that would fall in the category of child pornography. If the child didn't consent, then that goes back to the higher level there. So it's basically carving out that if they fall into these categories, then you're not getting the special treatment under this part of the law.
Right. So, but could the child in number 4 be penalized then?
They could be penalized if the child was coerced or just threatened or intimidated into committing the conduct. That is a different. And Delegate Shetty, why don't you speak to that? Because I think I see where Delegate Erican is going. If the child was victimized or coerced, why should it be treated differently than the rest?
Right.
I think that becomes a defense. Right, Mr. Chairman?
Is that written in the bill?
No, because we had to remove the affirmative defense section, and then instead we changed, we created this as one of the factors. So this would be like where I guess the state's attorney would look and see whether to bring charges. This would be one of the factors that they would.
Right, and I think they should bring charges against whoever did the coercing, but my concern is if we include it in this part of the text, we don't create a separate exclusionary rule that says they also can't, that they can't charge the child in this instance, because if we're excluding them here, they could still charge the child with the child porn, that just for being coerced, which doesn't make any sense to me.
I think to Delegate Shetty's point, I don't think that the state's attorney would be charging a child for effectively for possession of child pornography that they were coerced into making.
We would hope not, but we see funky things often. Like this bill was inspired by a funky prosecution, you know?
Well, I mean, the bill was, I mean, the situation there was that they basically just said, was it child pornography? Yes, it was child pornography. Did they possess it? Yes, they possessed it. We're done. And so,
yeah, but they didn't have to prosecute, but they still did.
Yeah, but I think there is a distinction here, I think. But
is there a way that council could clean it up so that there's no option that a child that didn't consent is not included in the same collection of exclusions? Like, is there another, like, could we do a 3, 1, and 2 and say, you know, this is not considered sexting, but the children also should not be prosecuted for being.
Mr. Chairman, may I add something to
Delegate Shetty?
Thank you. Delegate Ercan, I think this is a really helpful point, but I think this is a section that is defining essentially what like a victim is. And the prosecution is not going to go after a victim to bring charges against them. They're not going to do that. Like this is, so I hear what you're saying, but I think I don't know that this would actually play out the way that you're concerned.
Yeah, I mean, I see it's probably a long shot that anybody would do that, but we've seen weird things before. So, you know, I'll do whatever the will of the whole is. I hate to leave things with like kind of sloppy edges, because who knows if we'll be back here in 10 years with some weird case where some nutty prosecutor decided to prosecute a kid who was coerced into doing something because of some extenuating circumstances that we don't understand. You know how they do. Oh, you don't understand the totality, or you don't understand the extenuating circumstances. This kid was a bad kid, you know? So anyways, it's fine. We can move it just how it is. But I just think it's a little bit weird to put it the same exclusions under there with both victims and with perpetrators. It just feels a little weird to me, but it's fine.
That's fine. I guess that it's, it's worth mentioning that you kind of following the same thought. You might need this in the child pornography law generally as well, which opens up another can of worms that I'm not sure we want to do, but the vice chair, then delegates Cox and Grammer.
Thank you, Mr. Chair, and thank you, Delegate Shetty, for your work on this. I'll just, as a side note, I really like the part about coming back and including sex ed in middle school next year about texting. But just a quick question, because I don't know these definitions off the top of my head. So in that first paragraph, we're explaining sexting, the sending of a photograph, image, or video that depicts sexual conduct in the criminal law article, blah, 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 of oneself to another. Does that include sending a depiction of oneself with another person or something to another individual? Is that included? Does that make sense?
Delegate Shetty.
Thank you. Thank you, Madam Vice Chair, and thank you, Mr. Chairman. So I think the second clause of oneself and the recipient is meant to include that.
Say that again. Oh,
yeah. So the of oneself to another is like the sender on their own, and then
right. So my question is, what if the sender is not just sending a picture of themselves, but is sending a picture of themselves with somebody else? Or
yeah, so I think the second clause is meant to address that by narrowly restricting it to like and the recipient. So it's like, so this is meant to capture like in the context of like two parties that are in a relationship together. Right. So like the sender and the recipient together, an image that they've taken together, the sender sending it to that recipient.
So what if there's a third party? So the sender and a third party sending it to the recipient. That's my question, I think.
This language does not capture that scenario.
Okay, so I'm just wondering if it should, but I'm just.
That third party may not have consented to that.
Well, what if
they do? Yeah, this language does not include that, I believe.
Okay. I'm just wondering, like, what if
I kind of wonder whether the legislation would become on a feedback loop at this point, because you'd have to, but that would become a greater challenge. But I see the point there.
Okay.
Delegate Cox, then Grammer, then Cardin.
Thank you, Mr. Chair. And I had a similar question, but also in the context of Snapchat, I think that case that brought this to our attention was a Snapchat case. And I'm not sure if this bill addresses that issue. And then secondly, was this final version, is this, I didn't find this one in my amendment bill list. Is this a separate email, or where do I get a copy of it?
I think there were two emails. One of them had the interlineated copies, and then one had the actual amendments themselves.
So
and the concern I think that we had coming out, for what it's worth, coming from the committee, is that the interlineated copies, it was a relatively large email, so I'm not sure. You still should have received both of those.
I'll check. Thanks. And then, so Delegate Shetty, about the Snapchat issue, how does this address that?
Are you talking about the scenario in which like an image is not retained, or like I don't have Snapchat, so I don't really know what you mean by that question. I'm sorry.
Well, I don't have it either, but from my understanding is the young person that was prosecuted had shared their video or something, and it got uploaded to Snapchat by somebody that had permission to have the video, I guess. And so then it went apparently to the whole school. Does this zero in on protecting from that, or how do we handle that?
Yeah, I think when you are talking about broader distribution of an image, you're discussing kind of like that the individual who is a part of the image likely didn't consent to that. So this language includes consent requirements. So I think that that's how that specific scenario is addressed. Also, it's specifically to the sending and receipt to oneself or oneself and the recipient. So I think broader distribution, it goes beyond sexting. Sexting is just between like one party or one party and the recipient to another party. Broader distribution goes back to like the remainder part of the criminal code.
Like Cox, again, we're carving out I don't know that I need to say it any more than that, actually. We're carving out a very specific set of circumstances for when two people are engaging in this, not in the broader dissemination of the child pornography.
Right.
Delegate Grammer.
Thank you, Mr. Chair. And I do appreciate Delegate Shetty reaching out to me to speak to me about this. I think you've done a great job. I have a question specifically about the recipient clause. And I'm more inclined to focus the offense on the behavior. And I'm just really wondering, so if I send this starting here, this behavior is inadvisable. But if a person sends this material to a person of equal age, it is considered sexting, but they send it to 3 people, one of whom is 5 years older, then that is not sexting. And they may be subject to child pornography. Is that how I'm reading this?
Delegate Shetty.
Yes.
And that's the intent. I hate to even go there, but you know that these are scenarios which very well may come to pass. And if it's the intent to say like, look, we have a bound, don't cross it. You know, I think I just want to clarify that for myself, but that may be a loophole which someone would probably step through, which is going to lead to someone getting prosecuted for the behavior.
But I feel like if you're sending it to multiple people, in particular, raising the real possibility that they're sending it without their consent, and they're sending it to people who are older than the 4 years old in the bill, I mean, then that juvenile. So remember, the person who is going to be able to take advantage effectively of the sexting statute is somebody who's 18 and under, or under 18. I'm sorry.
Come sit at the computer.
Delegate McComas, you're not muted. Is 17 and younger. So you're dealing with that first. If they're sending it out more broadly, well, that looks a little bit more like you're distributing something as opposed to 2 people who are engaging in something consensual. That actually, for what it's worth, was part of the conversation with when the Pages contacted the committee. They were talking about, you know, this does happen, and it happens with 2 people who are consenting to do it with each other, and send those pictures back and forth to each other. So again, what we're doing here is we're creating an exception in the law that says, if this is between 2 consenting people and they're within a certain age range, then we're going to treat this separately and at a lesser level than if you send it around to 5 different people or 10 different people, or even 3 or 4 different people, because that looks more like distributing child pornography, especially if it was somebody who was outside the 4-year time limit.
Okay, I appreciate that. And I'm going to put on my dad hat and say, Pages, don't do this.
I put on my mom hat when I spoke with them as well. So I think we're good.
On behalf of the whole committee, Please don't do this. Delegate Carden.
Thank you, Mr. Chair. Just a couple quick questions. First of all, I love the bill. I just want to make sure I understand. So can Delegate Shetty, can you give me an example of how you shouldn't have to have the affirmative defense and how that helps them? So that basically the allegation that somebody was coerced is no longer has to be backed up by testimony from the victim. Can you just explain to me the affirmative defense?
I mean, I'm not a trial attorney, so this is a harder question for me to answer. I'm really sorry.
Okay, no problem.
Yeah.
Maybe, Mr. Chair.
Yeah.
Give me the question again.
So I'm just trying to figure out, so we got rid of the affirmative defense. And I want you to give me an example of how that helps the prospective victim in this.
So Mr. Chair, if I can just share a little bit of what my understanding is without, again, I don't want to overstep because I'm not a trial attorney, so I don't want to describe this incorrectly. But my understanding from our conversation with the advocates was that if it was structured as an affirmative defense, it would require a teenager who is already unlikely to say like, well, so-and-so made me do it, because that would, make them, the uncool person that ratted out somebody else. Versus like, if this is part of the definition, it's like a screening tool almost as part of the decision that the prosecutor makes on whether or not to bring charges. That's my understanding, but Mr. Chairman, I defer to you.
I'm just trying to figure out, so when do we, is it that you just don't need to show coercion? I mean, I'm not exactly sure. If you get rid of the affirmative defense, how does that help in any way? I'm just trying to figure that out.
I think that again, we're creating this subcategory that takes it out of the child pornography possession statute for juveniles. So you have to think of it, we are creating a new crime to some extent, but we're not creating a more severe penalty. So what we're saying is, if you coerced someone into getting or participating in this, that's not under this. That is pornography. So the person
they're gonna need to.
Right. The person who did the coercion can't claim, oh, we were just sexting. That is why it lives in, as you can see on the screen, in A2 Roman 4. That's why it's there in that part in that part of the bill, is saying we're not going to let you say that is sexting. The affirmative defense, it does make it considerably harder. You effectively have to, the child would have to say, I was coerced into doing it, and that does put them in a far more, I think actually Delegate Shetty put it just fine. It puts the child in a greater problem. And if they were the ones who were coerced, that is not the position we want to put the child.
Right. I understand that. I just want to make sure it's sort of a little,
even more, it does put a burden on the estate's attorney to show that there wasn't coercion. It also puts a burden on the state's attorney to some degree to say, okay, that there wasn't coercion here.
And lastly, if you have a 13-year-old and a 17-and-a-half-year-old, and it was the 13-year-old who was a very shrewd kid who was coercing the 17-year-old, then you would have to deal with that under the child porn statute and charge him as an adult?
No, they're not charged as an
adult. He's not charged as an adult at 13 for possession of child pornography. He can't be charged at 16 for possession of child pornography. He can be charged as a juvenile.
You can't use the sexting because it's up to 4 years. And
yeah, you can't use the sexting. So that coercive 13-year-old, and on my list of quotes from this section now, the coercive 13-year-old's getting written down. could be liable for possession of the child pornography.
All right, thank you.
Although I gotta say, to bring out another law school thing, I think we're reaching a rules against perpetuities kind of level of debate on this bill. Delegate Arakan, and only here in Judiciary would you get a laugh for that. Delegate Arakan.
Let me see if I can like do a macro on this. Okay. Because I feel like we're really sort of bleeding into the weeds now. Okay. The goal of this bill is to take some intimate moment between consenting partners and protect it from criminal penalties.
Yes.
Okay. And then separately, any coercive or non-consensual behavior to leave it in the other statute. So we're really only trying to protect essentially innocent moments of youthfulness that probably their parents should have talked in more detail about what you should put on the internet or via texting and phones. I'd have this conversation daily with my children. Don't take pictures of anything unless it's a flower. And you know what I mean by flower, actual flower. So that's what we're trying to do. So I just want to make sure that at least my people understand we're only protecting and putting in a cocoon these few moments over here. We are not addressing sort of any kind of endemic problem where children are sharing inappropriate and disgusting things of other people.
Correct.
Okay, good. Glad I did that macro level for everyone.
And a half hour later, I think we've got there. Delegate Fisher, Juanita Fisher.
Thanks, Mr. Chair. I was raising my hand to move the bill favorable as amended. And
All right,
there is Shetty for your leadership.
We need to move the amendments. Is there a motion on the amendments?
So moved.
So moved. And is there a second?
Second.
All right, motion and a second to accept Delegate Shetty's amendments. All in favor of the amendments, please raise your hand. Cardin, Shetty, Moon, Griffith, Arakan, Bartlett, Lopez, Williams, Atterbury, Cham. I can't tell what Frank Conaway is doing. Crutchfield, Malone, Grammer. I can't tell what Delegate Juanita Fisher is doing. Is a yes. Deborah Davis, Rachel Jones. All those opposed. Delegate McComas. All right.
Vote me in the yes, Mr. Chair. I missed that.
Okay, and Delegate Watson is a yes.
Thank you.
All right.
Move the bill.
Move the bill.
Second.
There's a motion for favorable and a second. Any further discussion? Seeing none. Do a roll call. The Vice Chair,
Yes.
Delegate Arakan,
Yes.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway, Delegate Conaway appears to be distracted. Delegate Cox,
No.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher,
Yes.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
No.
Delegate Moon,
Yes.
Delegate Shetty.
Yes.
Yeah, you better after all that. Delegate Delegate Cham,
Yes.
Delegate Ron Watson.
Let's see, what am I supposed to do here? Can I pass?
No.
It's on the bill, Watson. It's on the.
Be with us or be with McComas?
I'm with Cardin. What did you
That
vote?
would be
Cardin?
yes.
Delegate Watson apparently votes yes.
That's a yes.
Delegate Williams.
Yes.
All right.
Back on.
Delegate Conaway.
Yes.
All right. Delegate Conaway makes it 18 to 2. Okay, we're only an hour in. We'll go now. Let's. Why is that one? All right. And we did that one. And Where are we? 231. We'll do 231. All right, 231. It went to the Criminal Law Subcommittee, and there are amendments. Delegate Moon.
This was the bill, the panic defense bill. We voted this last year. It doesn't allow you to downgrade a charge on murder or assault on the basis that you discovered one of the identities listed here: race, color, origin, sex, gender identity, or sexual orientation. There was an amendment that came in by request of the state's attorneys, and it just includes all degrees of assault can't be downgraded. So that was what the subcommittee adopted. Again, we already voted this bill last year, so I would move the amendment.
Second.
Motion on the amendment and a second. Is there further discussion on the amendment?
Move favorable as amended.
Seeing none, we got to move the amendment first. All
Sorry,
right,
Mr. Chair.
seeing none, all in favor of the amendments, please raise your hands. Delegates Cardin, Shetty, Moon, Griffith, Arakan, Bartlett, Lopez, McComas, Williams, Atterbury, Cham, Conaway, Crutchfield, Malone, Grammer, Fisher, Watson, Davis, Jones, Cox. That amendment is adopted. All right, we're on the bill as amended. Is there further discussion? Delegate Cardin.
Mr. Chair, and as I mentioned earlier on the Stewart bill, that we included gender identity into the hate crime statute. I got calls from the Baltimore Jewish Council and looked into by some issues from the AG's office about this bill and the way to actually make it proper, instead of specifying the protected classes in this bill and missing certain classes such as religion in this bill. They had suggested that we attach it to the enumerated classes as defined in the hate crime statute. I brought that amendment to the subcommittee at the time. The subcommittee amazingly discussed it, realized that it's probably the right thing to do, but per the MO of Delegate Moon, didn't want to mess up what was happening with amending bills differently than the Senate, blah, 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 back and forth. Free State Justice actually said the only issue they have with it is that gender identity was not specifically enumerated in the hate crime statute. Well, we just passed legislation that's going to do that. So their, I wouldn't say objections, but their concern was fixed. And even though it was already in the hate crime statute, just defined a little differently. So one of the suggestions that we had was don't deal with it in this bill, which is why I didn't raise it when we were talking about amendments, but consider putting it onto the Senate bill and then having this bill be able to go as the Senate passed it so that it can pass, and then maybe have it go to conference if we amend the Senate bill. I'm just raising that issue because it does clean it up. It satisfies the issues of the Attorney General's office and the issues of, for whatever reason, not having religion as part of these protected classes, which I don't think is appropriate. The other thing that it would do is, as things are added to the hate crime statute in future, if we have other protected classes that we're not aware of, instead of having to change the entire legislation, it would just automatically change as things move, and it wouldn't have to be specifically enumerated. That's my comment, and I'm going to vote for the bill, but I do think we ought to consider that when the Senate bill comes over.
There further discussion on the bill? There was a motion for a favorable and a second. Seeing no further discussion, we'll do a roll call. The Vice Chair?
Yes.
Delegate Arakan?
Yes.
Bartlett? Delegate Bartlett?
Yes.
Delegate Cardin?
Yes.
Delegate Conaway?
Yes.
Delegate Cox?
Yes.
Delegate Crutchfield?
Yes.
Delegate Deborah Davis?
Yes.
Delegate Juanita Fisher,
Yes.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
Yes.
Delegate McComas,
Yes.
Delegate Moon,
Yes.
Delegate Shetty.
Yes.
Say that again.
Yes.
Okay. Delegate Champ,
Yes.
Delegate Watson,
Yes.
Delegate Williams.
Yes.
That should be 20. Okay. Go now to House Bill 260. Delegate Juanita Fisher. What is Delegate Fisher trying to do today? This went before civil? No,
Yes, Mr. Chair.
it went to civil?
Yes, it went to civil.
There are no amendments, I don't think, to this bill. Is that correct?
Correct, Your Honor.
Move favorable.
About jury
Second.
service.
It's about jury service. There's a favorable in a second. Does anyone want to have any discussion about the bill? Delegate Erican?
Just remind me again, Delegate Cardin, what this bill does?
Sure, this bill repeals the provision to disqualify people who have previously received a sentence of imprisonment of greater than a year. And it just, instead, an individual is disqualified from jury service if the individual has been convicted of a felony and is currently serving service or still on probation.
So what kind of misdemeanors does this now allow for people to have committed to be on?
Allows
jury?
anything, except that they can't be serving or still doing their probation.
So they could have assaulted somebody or raped somebody and still be on the jury.
Yes,
So our goal is to have actual criminals serving as just the deciders as to whether or not other people are actual criminals.
Mr. Chair, can I take that question?
Delegate
sure.
Juanita Fisher.
So I would say to Delegate Erican, I think the goal is for restorative justice and citizenship. So in our system, when you commit a crime and you are either found guilty or you plead guilty, whatever it may be, you serve your punishment, whether that's incarceration or fine, etc. You may or may not be on probation. So you do your probationary period. And then in theory, you are back in our society as a full citizen. Maryland has led the way on this, restoring voting rights for felons as well. This is really just adding that hole in. You would be part of our jury selection pool, which is there for all of our citizens available. Now, this would also be in the criminal and the civil context. And the ability to voir dire people for various reasons is still law. And I think if we are a society that says if you serve your time and you finish that, you are now back in our society and not forever punished, forever seen as a different type of citizen. I think this bill addresses that concern. So that's what it's about. I wouldn't frame it in the way in which you did, but that is how I frame this issue.
Okay, I hear you, girl. I got you, but I'm like, there's two issues I'm having here. Like one, the voir dire is restricted, right? You can't just voir dire everybody out. So if there's a big amount of people that have all committed some kind of crime, how many strikes do you get, Mr. Chair?
Well, let's go ahead and let's walk through that, because I think that'll be full. So
I was about to do that.
Yeah, I got it. So with no offense, first you have the panel and you have the voter file list. Basically, they get the voter list at the jury office. They randomly draw from the motor and voter rolls. They get groups of people who come to the courthouse and decide to spend the day with us in lovely downtown Annapolis. If they're coming to Anne Arundel or wherever your circuit court is, they come in. They sign in, and then they are given a number. The numbers, 1 to 400 are usually, give or take, maybe less. Depends on what jurisdiction you're in. Maybe more, depending. Baltimore City, it's sometimes more. Other places, sometimes less. If I have a case let's just say it is a robbery, armed robbery. I'm probably going to ask, and the defense counsel will ask, for about 40 jurors. Could be more, but generally speaking, it's going to be 40 jurors, give or take. They're going to come in, they're going to go through voir dire. They're asked a series of questions. Usually those questions do include, have you been a victim of crime? Have you ever been convicted of a crime? It goes to a wide range of other issues related to whether or not they have strong opinions about the criminal justice system. Have they gone through cases before? Have they had civil cases before? In some cases, you could have a range of different questions that can be asked in voir dire. Those people, usually what happens is people stand up if they want to answer yes to those questions. Then they go to the bench and the judge addresses each one of those jurors individually, along with the state and with the defense counsel. If somebody comes up to the front and says, in the example that Delegate Arakan said, and let's say I'm in an armed robbery case, I have been convicted of armed robbery, and I've been convicted of armed robbery 20 years ago. Since then, I have gotten my GED, a BA, and I'm working on a PhD, and I own a small business, and the judge is going to seek to make a judgment based on that question and a range of other questions that the judge will ask about whether the person who's standing before them going through voir dire can fairly and honestly make a judgment in this case that won't be biased based on their previous experiences. There are a range of questions that can be asked. The judge can decide on a motion of either side to exclude somebody for cause. So, for example, in Delegate Arakan's case, if you're there for a sexual assault case and the person had been convicted of sexual assault, had been convicted of a sexual offense, at least in my experience, this means it's a certainty to Delegate Arakan's soon to be made point, but almost all the time they're getting struck for cause and knocked off the jury. After you go through that initial process, the state and the defense can make challenges to individual jurors. And depending on the kind of case, it could be 4, it could be, my brain just stopped as to the maximum, but it could be up to that's right, up to 10. So, and it depends on the kind of case. If it's a murder case, you have a much larger panel and you would get the 10 strikes. So it's
Okay.
in that case, if they didn't get struck for cause, the state would probably strike them on the end.
Okay, so just to make sure, Delegate Fisher, your intent is not to have people who are actually convicted of rape then later sit on a jury rape trial. That's not the intent of the bill.
My intent of the bill is to have restorative citizenship for people that have served their time.
So potentially we could end up seeing somebody convicted of the very crime that they're sitting on a jury for.
I think I've personally spent a lot of money in law school and being a member of the bar, and I have faith in our justice system. And so this bill is about giving people their restorative participation into our society. And I think our justice system will work. Otherwise, I don't know why I'm in court every other day. I think it will work. And so I think the explanation that our chairman so eloquently gave you on how jury service is done, and that people will enter the system and the system will sort itself out. That is my intent, is for if you served your time, you're back being a citizen. Or those that don't believe in this bill should be comfortable saying, once you commit a crime and you serve the full extent of the punishment of their crime, you are no longer a full citizen of the state of Maryland. You will always be a different class of citizen. You have to be comfortable saying that, I think, if you don't support the bill.
I think for people that are still in the sex offender registry, I would be shocked if anybody would be comfortable with somebody on a sex offender registry serving on a jury for the same crimes. But that's just my opinion. Thank you.
Delegate Cox.
Thank you, Mr. Chair. And I'm just going to re-echo two things. First of all, as we discussed in committee, this bill will in fact allow a child sex offender, could have even murdered a child through this alleged restorative process, to then sit on a child sexual abuse trial. And I think that's egregious. It's outrageous. I think there's also a concern, though, if you consider the fact that the judicial canon of ethics does not permit a judge or requires a judge to recuse themselves if they have conflicts of interest. And yet here we could have a jury with direct conflicts of interest in their past, handling cases that they really shouldn't be handling at all. I think that was the intent of the statute, just simply not to prevent restorative justice, where you have somebody that might have a debate on whether or not they should be restored full voting rights or other full rights, like the right to keep and bear arms. But this has little, I think the law currently is just to prevent these direct conflicts of interest, particularly in the case of egregious crimes.
And I actually really do appreciate that perspective, Delegate Cox. I would say to you, though, from my lens and the way justice in our system has not always been served to all of our communities, I do think that individuals feel that their full rights in every way, being a full citizen, whether you're being pulled for jury service or your voting rights and others, is a part of being restored to the society as in a full way. So I understand your concerns, but I also think that our jury selection service takes those conflicts of interest, in mind. Even in the civil context, I was doing a trial, in a personal injury suit last year, and people have come into that with all kinds of biases from different things, and it might not just be your record, right? Biases throughout just human existence, and so we do the best that I think we can in our system to have juries be neutral and impartial systems that are there. And so that's a reality that we're dealing with every day. So I would just encourage this committee, this bill. I also forgot to say, this bill passed out of our committee last year and passed on the floor of the House last year. It was just COVID that I wasn't able to move on the other side. But I would encourage people to support this legislation. I do think it is about us looking at individuals back in the society as a holistic way. And I think the reality is our jury, the system in which we do jury selection is there to account for all types of biases that come from all experiences, not just your criminal record, but for tons of experiences, whether you're in a civil or a criminal trial.
Delegate Griffith and Bartlett.
Thank you, Mr. Chair. Well, first I would say that, I know it was expressed that, we have confidence in the criminal justice system, but I think this very bill, as well as a host of bills we're hearing this year, shows there is a lack of confidence in the criminal justice system, warranted or unwarranted. So to simply put our faith in the criminal justice system that this will play out the way we want, I think is not exactly the best assessment. However, and this is a question, under this bill, is it potential that someone who committed some sort of crime against a child dealing with pornography would have eventually access to those images of another crime of the same nature? And are we literally putting child sex offenders, literally handing them additional pictures of child pornography?
Delegate, is that question for me?
Delegate Fisher.
I just for
anybody. Oh, okay. Again, I think that is a very interesting example that you want to put. I don't think that is anyone's intent. I think the intent of the bill is that people participate on jury service.
Is that possible? Delegate Fisher, I don't mean to cut you off.
I don't want to say things are impossible or possible in every case in the state of Maryland. I would be shocked that of the judges that I've been in front of in courts in various counties in our state, would that person would pass the disqualification as Mr. Chair laid out for you, and that person wouldn't be used as a strike. I just don't see that. But I can't sit here, Delegate Griffith, and tell you every scenario is impossible or possible. It's a process. Every case is different. Factors are different. People are different. Counties are different. And I think when I say the system is not perfect in the fact that Maryland incarcerates more Black men than Mississippi. Obviously, I don't think the system's perfect, but I believe in my state. I believe in that the work that we do here every day is to make the system more and more fair for all Marylanders. And part of that is allowing all Marylanders the ability to participate in jury service when they finish their time. And I think that's where we're all here, is to make our state better, make the system better, and to me as well, make criminal justice better. So that would be my response to you. I think that is what the random example that you gave is highly, highly, highly unlikely, but I'm never going to say the word impossible or possible. It's a system. People have cases. We come back to Annapolis with all types of bills. So I'm not going to say that, but I think it's highly unlikely. Yes.
So you muted again. Sorry.
Sure.
So
I was yielding to Mr. Chair.
Oh, sorry. Two more follow-up questions. Very simply, is it more likely under this bill that could happen?
I mean,
I'm not a probability expert, but I mean, you're adding people who finish their crime and finish their probation. So they should, they finished what we said they needed to do because they did something wrong. They committed a crime back into the option of being pulled,
So it's more likely. So it's more likely someone who committed some kind of crime involving children so it's more likely that someone who committed one of these crimes as part of a jury selection, or even somehow they make it through and become a jurist.
No,
I don't think oh, go ahead, Mr.
Actual
Chair.
evidence of another crime against somebody else.
Delegate Griffin, I believe actually it's less likely, probably very much less likely, and here's why. So similar to voting rights that we've restored back now to all ex-felons, except for ones for very specific enumerated crimes. This essentially restores jury rights to all people who have committed crimes. However, what it does is it allows and it expects voir dire to be much more pointed, particularly at conflicts of interest or inability to be unbiased by the judge. So the judge, instead of in every single jury trial that I've either watched or I've been part of, a judge asks, have you been convicted, or are you a victim of a crime? But then he qualifies that. If somebody raises their hand and says, yes, I was convicted of a crime, he says, does the fact that you were convicted of a crime inhibit your ability to be unbiased in this situation? Now, first of all, the vast majority of the jury trials are probably civil trials. There's just more civil trials than there are criminal trials, just generally speaking. So are we saying the same thing about if you've ever been in a car accident? Should you not be able to serve on a jury for a car accident? No, we're not saying that. So this is just about.
One last question. I don't mean
excuse me, Mr.
Hang
Chair.
on, Delegate Conaway, wait a minute.
I definitely have to go.
Oh, I'm sorry, and I know why. There's a Baltimore City delegation meeting at 12:30. All right, Delegate Conaway is going to go to the city delegation. All right.
Would this include individuals who committed a hate crime? Would they be allowed to serve on juries as well?
If they have completed their sentence, they would be able to serve on juries. Again, there's no, but they would be able, but the judge would voir dire them if they found that they've been convicted of a hate crime. You can be assured that the judge would be very hesitant to allow them to serve on a jury if it is in some way. That's the way it works now. This is just bringing more transparency and daylight to the fact that we have to figure out who's going to be the best people to serve on these juries.
Well,
that's why I think that Delegate Fisher's bill is really, it's not just restorative justice, it's actually bringing transparency and daylight to the jury selection system.
Well, I will be voting no because I don't want people that can potentially allow people who committed crimes against children or people that committed hate crimes on any of our juries. Thank you.
All right, here's what we're going to do. We're going to have 3 more comments or questions, and then we're going to move on because, as was mentioned, the city delegation is meeting right now, and I am part of the city delegation. So I can't be in 2 places at once. Well, although these days maybe that we can. Having said that, Delegate Bartlett.
I just wanted to make a comment about the assumption that's being made. There's an assumption that if someone has been convicted and served their time, that they will be soft on a conviction of someone else. And quite frankly, I think that's a flawed assumption, because in some cases, I think they may be tougher because of what they have gone through, and because hopefully because they have had some level of restorative nature. So they know that this was, that's the whole purpose. They're supposed to be restored. They're supposed to be rehabilitated. So I think that's an assumption. I also think it's a false assumption that if you have a victim, that victim is going to somehow be swayed one way or the other, which is the reason why, and I appreciate what Delegate Cardin said, which is the reason why you are asked, have you ever been involved in this type of case? Quite frankly, it's the entire case. Have you ever been involved in a case involving this, whatever's going on? And the reason for that, I agree that it is a level of transparency. And the third assumption is that people even want to serve on jury trials. A lot of people don't even want to serve on jury trials. In Anne Arundel County, I think you get $10 a day. And quite frankly, I'm hoping that people make more than that in a day than they would. And I'm not picking on Anne Arundel County by no means, because I'm from Anne Arundel County. Anne Arundel County is great. But my point is that I think there's some false assumptions that are being made. And I think it is a great bill. I will be voting in favor of it. And I do believe in restorative justice. If you serve your time, you serve your time, and you're supposed to get back into society.
All right, Delegate Cham.
Thank you, Chairman. Okay, so all right, so let me see if I can conceptualize this in an intelligent manner. So I love your example of a person who served their time, 20 years later, got their degree, they're on to a good path of life, their sins have been forgiven, and they are productive citizens in their communities, doing great. So is there, that's a great scenario. 20 years later, they're great. So for the other person who has just gotten out of prison, they're off probation, it's a year or 2 later, is there anywhere in this bill that talks about, so say they're off probation and 6 months later, they happen to be the lucky recipient of getting selected for jury duty. Is there a stipulation? Is it months or year after your probation has ended, you can be eligible for jury duty? I mean, I'm a proponent of second chances. Everybody deserves grace extended to them. You've served your time, you're back out, you're working, you're doing the right thing, you're making good choices in life. This one is a little hard for me, I'll admit. It's a little difficult for me. I've been thinking about this bill all weekend. So is there any kind of stipulation in this bill, a room for,
99
probation has ended 2 years after you've not broken any laws, you're doing good things? Or can it be your probation ended today, March the 8th, and March the 15th, you got jury duty summons in your mail?
99% of the time, Delegate Cham, you have, after a criminal conviction, and we're talking about serious ones, you have a period of probation. The probation is your chance, usually it's supervised, not always supervised, but it's your chance to prove to both the department as well as to people around you that you are able to successfully weave your way back into society in a law-abiding way. Usually it lasts for approximately 3 years. Is that correct, Mr. Chair? I mean, it could be less.
3 or 5, depending on the severity of the crime.
Could be less. It can't be more than 5.
Could be more. Can't be more than 5. But yeah, district court cases usually no more than 3.
So if you're successful for 3 years integrating back into society, why shouldn't you be able to fully integrate into and be part of this system just like everything else? That would be my argument.
Are certain crimes, do certain crimes eliminate you from or prohibit you from serving? Murder versus robbery?
Not in this, not according to this legislation.
Not in this bill. And if I can make a brief comment, Mr. Chair, I'll be very brief. I think, Delegate Cham, I appreciate your concern and thoughtfulness on this legislation. It is a very important bill to me. And I agree that these things should be done with care. And I think it is very hard for us to draw a line of this crime is this and this crime you can't. I think that's very difficult because as you've experienced in your time here, victims for all types of variations of crimes, from misdemeanors all the way to the most heinous murders, all feel how they feel, right? And so I think it's very hard for us to do that. And I think that's why this bill is very intentional in that when you served your time, you served the probationary period, you would be restored as your voting rights would be restored, because it is very difficult to draw that line. And I think we'd be discussing, if that was in the bill, I think we'd be discussing it all night on which crime would qualify and which one would not.
Thank you.
Thank you. I see Delegate Lopez. Are you something brief to say? That's fine, but otherwise.
Yes, I just want to thank Delegate Fisher for putting forward this legislation. Great move towards transparency, restorative justice, and just anecdotally, as someone who has been selected for jury service every single time I've been summoned, I appreciate broadening the pool. So I would move the previous question.
How are you that lucky? All right.
Jury too. That was a long one.
It's kind of remarkable. I did misspeak before. People who are sex offenders can get a longer probation. Sometimes that probation is tied to their being on the sex offender registry. Having said so, all right, we've got a motion to move the previous question. Are all in favor, say aye.
Aye.
Any
Aye.
opposed?
Opposed?
Okay, I believe there are people who are opposed, but I believe that the ayes have it. We'll go to the bill. It is not as amended. It is straight favorable. Any further discussion? We've already had discussion. We'll go to the roll call. The Vice Chair.
Yes.
Delegate Arakan.
No.
Delegate Bartlett.
Yes.
Cardin.
Yes.
Conaway is excused in the city delegation. Cox.
No.
Crutchfield.
Yes.
Deborah Davis.
Yes.
Juanika Fisher.
Yes.
Grammer.
No.
Griffith.
No.
Rachel Jones.
Yes.
Lopez.
Yes.
Malone.
No.
McComas.
No.
Moon.
Yes.
Shetty.
Yes.
Cham.
Chairman, I apologize if I'm out of order. May I ask another question?
I'm sorry, at this point, we're in the roll call. I can't do that. I'm sorry.
No.
Okay. Delegate Ron Watson.
Yes.
Delegate Williams.
Yes.
It's 12-7. All right, here's what I have to do now. We have an amendment would be proposed as a committee amendment from Delegate Deborah Davis to House Bill 670. You might recall when we were last together on Friday, there was an amendment that was missed in the amendment packet. You should all have it now. And it basically addresses two issues. It addresses it adds that each law enforcement agency shall post in a prominent public location an explanation of the procedures for filing a complaint of police officer misconduct and the procedures for a request to obtain records relating to a complaint of police officer misconduct under the PIA. The amendment also seeks to, it adds to the training on use of force, indicating and adding requirements for training as to when a police officer may or may not draw or point a firearm at a person, and de-escalation tactics and techniques and reasonable alternatives to decrease physical injury. Delegate Davis, did I state that amendment properly?
Thank you, Mr. Chair. Yes, sir.
Thank you very much.
Move the amendment.
Second.
Motion is second to move the amendment. We'll have any discussion. Does anyone have any discussion regarding Delegate Davis's amendment, which would be offered as a committee amendment when the bill comes to the floor? Seeing none, we'll take a vote on the amendment. All in favor of the amendment, please raise your hands. Delegates Lopez, Shetty, Cardin, Bartlett, Atterbury, Williams, Crutchfield, Watson, Fisher, Davis, Jones, Moon. That's 12. All those opposed to the amendment? Opposed to the amendment, Cham, McComas, Grammer, Cox, Malone. All right, I see 12-5. If I missed someone, you'll let me know, but I see 12-5. So that'll be offered as a committee amendment when we go to the floor. On your voting list that we're not going to get to today, we're going to plan to vote tomorrow. And at this point, I'm going to set the time of the voting session at 7 p.m. tomorrow night. Because we're not going to be able to get to it today, and we're not getting to the rest of this list today. We are going to discuss tomorrow and move and be entertaining a motion tomorrow on House Bills 52 and 1312. In your packet, you should have received an interlineated version of both 52 and 1312 with amendments that have been put together. These amendments I'm offering these amendments, and I'll talk in greater detail as to what they do at our voting session tomorrow. Although, since we're here, in 52, the amendments do remove the eviction diversion program that created a fiscal note and significant opposition from the judiciary, but more importantly, the fiscal note. In the bill, it says that before filing a summary ejectment, they have to provide a written notice. We set up a different process for providing notice. The notice can come from 2 of 3, what we'll call notice buckets. So you can add that to your list of interesting phrases during the session. One of them would be a piece of first class mail. The second bucket is showing proof that the letter was taped to the door. The third bucket would be an email message or a text message. They would have to cover 2 of the 3. So if somebody didn't have a good email, they could send first class and tape it to the door. If they did have a good email, they could send it first class and send it by email, or they could tape it to the door and send it by email. But one way or the other, they would get a written copy of it. The landlord would have to affirm that they gave that notice when filing the summary ejectment. The court would issue a judgment, if that's what the court decided, the owner could take possession not in 4 days, but in 7. And also in the bill, the court can issue an emergency stay if eviction would endanger the life or health of the tenant. After the summary ejectment, again, after filing the summary ejectment, the bill would extend slightly from 5 to 7 days, the number of days to appear at district court. In 1312 in the bill as amended, as you'll see in the interlineated copy, it provides for the collection, not by the sheriffs, but by the judiciary, because they get the information back from the sheriffs, of data. It provides for the collection of that data and posting bi-weekly of that eviction data on the judiciary's website. Substantial loss of income would remain as a defense for an eviction during catastrophic healthcare health emergencies. So like this one, going forward, if there were another catastrophic health emergency, there's not, but substantial loss in income would still remain would be codified as a defense. That would also apply to this year as well. 1312, we would also retain the language that says that you cannot raise rent or charge fees or fines during a catastrophic health emergency. I don't want to begin discussion on it now. I know there are questions and issues that people have. I want to commend the bill to the committee. We all have a lot to do and to read. I would strongly encourage you to read House Bills 52 and 1312. There are other bills related to housing that also will start to appear in the next couple of days. But I want to start with these two because they are jointly assigned with the Environment and Transportation Committee, and we are primary. So we have to move first before they can do anything.
Mr. Chair.
Yes.
I just have a quick question. I know, I'm sorry, just because I'm not sure. If I wanted to add an additional amendment to 52, do I send that to you? What do I?
If you're interested in making further amendments, first, you can't draft an amendment.
Thinking with common sense.
You'd be drafting it to the bill. So keeping that in mind, you need to, we will accept amendments, and since it's 12:49, we'll accept them all the way up until 6 p.m. on the day, on Tuesday, when we address this in the voting session.
That comes directly to the committee, Mr. Chair, or does it have to go through the amendment office?
You need to go to the amendment office and request your amendment.
Okay, thank you.
All right, thank you very much. With that, we're going to stop. There are many committee hearings or subcommittee hearings and committee hearings that are coming up. Tomorrow we have a 1:30 hearing with 40 witnesses for the full committee, followed by the Family and Juvenile Law Subcommittee at 5 o'clock. We're going to give them time to continue their work. So it is possible that our voting session will start a little later than 7 o'clock tomorrow night. Wednesday, we have 1:30 hearings. I don't believe there will be as many witnesses, and the Public Safety Subcommittee is meeting at 5 o'clock on Wednesday. And then on Thursday, we have a 1:30 hearing, I think only with one bill. The Criminal Law Subcommittee will be meeting at a time that will be announced. I'll take these two questions and then I'm going to have to scoot. Delegate Malone.
Yes, I'm wondering when to expect a reprint of 670 from our amendments on Friday.
I think that is available and I will make sure that everybody has it.
And when do you anticipate it going to the floor in second reader?
I believe it was reported for, I think it's reporting for Tuesday.
Okay. All right. I'm looking for the reprint.
All right. Thank you. Delegate Grammer.
Thank you, Mr. Chair. I just wanted to try and get an idea about the schedule tomorrow, which is just session, committee, and then late voting. Is that what we should plan for?
Yes.
Okay. Thank you.
And I would expect that the better part of the rest of the way. All right.
Chairman, I can fold that last amendment in to the rest of the amendments so that they all are reflected on the reprint.
That's fine. That would be better. And I think everybody would appreciate that so that we don't have multiple reprints going around. So we will do it.
So there won't be an additional floor amendment tomorrow. I'll just fold it into the other set of amendments.
That is fine. Thank you very much. All right. That concludes the voting session for today, the 8th of March. We appreciate everyone and your time, and we will see you in subcommittee. Thank you very much.